Welcome to the first session at RSA today. So you probably have high expectations, right? Right. So it's all up to you. So if you all do well, then you'll have met your goal. What I'm going to talk about today, you probably wonder what CISO Spotlight is because you're not seeing like a big name company or anything like that up there. You can read in my bio if you like, but I've been a CISO for the last 20 years. So this is something that's not new to me. I'm also an author. I'm working on my fourth security book right now. I am doing a book signing right after this session, so I am going to make sure that we all get out of here on time. That's the one advantage of that. Over at the bookstore in Moscone South, which I'm glad to even announce that because I went over there earlier and I was looking for the book and it wasn't there. And they told me it was backordered. And then they said, oh, we made a mistake. So I just got an email, so they do have the books. But it's an information security governance book. I'll be over there. If you want to get a signature, it's worth $10 less with the signature. So you can get it later if you like. Well, let's look at privacy. Privacy is really a hot topic today. And it's fascinating to me because I started doing this session, and what we're going to try to do in the next 45 minutes is cram all the privacy concepts into 45 minutes. So you'll walk away at least with an understanding of what are the issues that people are talking about. What's this language? What's in these laws? And that's what we're going to cover. And how are some of these laws different? So we will go through that. 84% of American users don't know how to secure their email. 41% of children's profiles are visible to all, even though we may think that they're not. 56% of millennials will share their location for discount coupons. So there's a line, there's a price we're willing to give up for privacy. So we're going to talk about why security officers should care about privacy. We're going to talk about the language of privacy, the privacy common laws and principles, and then a privacy program design. So we all have different ways that we look at privacy. Some of us are willing to openly discuss our salaries with others. In fact, I read some things recently. People are having those kind of discussions. Hey, what do you make? I make. Wow, for a lot of us in this room, we would have never discussed our salary with somebody, right? That was something very private. And then we put things on Facebook. We put our parties. We put our pictures of our night out with our friends. Well, what happens when you do that when you're 17, 18 years old, 19, 21 years old, 30, 40, 50, I don't know, years old, and then you go and apply for a job. And people are doing looking at your profile that you think you had private, but really wasn't private. Now you have all those pictures out there. So we bring in some other concepts, things like right to be forgotten that are coming into play. And we'll get into that with the GDPR. We're investing in companies, Fortune 1 companies are looking at information security that the privacy area is important to security, and we can see that legal, information technology, and then it drops off really quickly. So if we look at those three groups are really aligned together. So privacy is really something that is important, and we can thank, who can we thank for that? Why do we have all this attention in the last few years on privacy? EU. Yep, they've had a big thing to play with it. What did I hear? Snowden? Yeah, thank you to Snowden, right? Because he brought all this up there and the government being able to look at our stuff. So Forrester came out a couple years ago and they were looking at what is it that the 2018 CISO, now this is very relevant because they projected this 5 years ago. They said that there needs to be a plan to move away from operations. How much did we see that today? If we look at the keynote today, we're talking a lot about how we manage information security and making sure that we automate things and leverage that as much as we can. We need to refine the risk management processes, but in the middle here, we need to widen the vision to data privacy, data management, and compliance. Starting to become a very important thing. So Forrester was noticing this a couple years ago, that this was going to be important. I put this little schematic together as to how I've seen the information security space evolve over the last 25 years. So we actually had the first CISO in 1995. Does anybody know who that was? He's going to be very disappointed. He started this industry. It was Steve Katz at Citibank. 1995 was the first named CISO. And that was back when, security was login IDs and passwords and so forth. Then we got into this regulatory compliance era, and we had all the laws like GLBA, HIPAA, FISMA, all of those came out in the early 2000s. And then everybody was doing all the checklists around compliance and security. So then we got this concept in about 2004 to 2008. Well, maybe we should look at this on a risk-based basis because we can't handle everything. And then from 2008 to 2014, we really went into more of a threat-aware, cybersecurity, socially mobile CISO. And if we look at what were the changes that happened around 2008, 2007, how did our world change? Financial crisis? Facebook and iPhones. Yeah, so look at the technology. That was only 10 years ago. But so we started to shift. We got away from that. We had to look at all these other things. The cloud was coming on, and so we looked at that. But about 2015, we really started focusing more on privacy. And the question was, where is our data? If we don't know what we have, and we don't know where it is, and we don't know the value of it, how can we protect it? And we only have so many resources. And so I think that the CISO that's going to survive in the future is going to be that person that gets all the data management around where the information is and how that stuff is being protected and how much we're going to spend on that. We have a new set of concerns. We have this lack of global trust. We have data that's everywhere. Each country wants to control its own information. They don't want the information to go outside. Just ask Germany, France, and Sweden about having information outside of those countries. And they're very protectionist around that information. And there's a history that we all understand behind why there is that protectionism. And there's things that you have to go through. We have new regulations and fines. We'll get into the GDPR, the General Data Protection Regulation, and what those fines are. Breach notification. We take it for granted here in the US. That was from Senate Bill 1386 from California back in the early 2000s. Europe has not had a breach notification law. GDPR fixes that. So those are standard things that we're starting to see. Location tracking. Do you want to be tracked everywhere that you go? Do you want to have to give permission to that? Because we all have these devices in our pocket now, our location can be tracked. And then we have changing responsibilities. We have data protection officers. So we've had a lot of global work and discussion that's being done around privacy. Privacy also impacts our daily lives. We have to think of privacy in terms of oral communication as well, because those have to be kept secret. So we always have to remember, what we say in elevators in different places. Privacy is not a new thing. We trace it back in the US to an article that was written in the Harvard Law Review in 1890. And it was the right to life, right to property, right to enjoy life, right to liberty were a lot of the rights that were available at that time. So why did privacy become an issue? What was it that brought these two lawyers to write an article about the right to privacy? Yeah. What? Photographs. Exactly. Mind if I take your picture, do you? There you go. Okay. I'm kind of old school. Yes, it was photographs. And it was because the newspapers at the time were big gossip columns. And so you would read about something that somebody said, but it was hearsay. But when you had a picture and you could print that, oh, then you had real evidence, right? And aren't we struggling with this today, more than 100 years later? You know, we have police officers with body cams, and we have people shooting videos everywhere. You know, we have that same thing. We worry about drones, right? That drone that's hovering outside your bedroom window. You might want to shoot that drone down, right? So we worry about those things. But it was the right to be let alone. And that was what they posited, that an individual has a right to be let alone, and inside their house, that is an area where a person has a right to privacy. And that's how we get into all the search warrants and all of that. But a person has the right to not have somebody come just walking in their house and they have that privacy. We've had a lot of laws and legislation since then. Sometimes the US is criticized because it said that we don't have any privacy laws. That's really not true. We've had a lot of laws. The US Privacy Act of 1974, for example, protected the federal legislation, protected federal records from privacy. And think of when this was. HIPAA came out it was a 1996 law. The final security rule didn't come out till 2003, and the privacy rule was in the early 2000s. Almost a quarter century later to protect our health records. But in the US government, there's always been this requirement. And we'll get into in 1980, the Organization for Economic Cooperation and Development, the OECD, came out with some principles, and we'll go through those 8 principles. But that's a key, was a key area in the treaties. In the US and Canada, we have what's called sectoral laws. In other words, we have about 50 different laws that address privacy, but they're all focused at different areas. So we have things like HIPAA that protect health insurance records. We have the HITECH Act, which expanded that and looked at the business associates for those healthcare organizations as well. Did some other things too, like trying to make meaningful use of the electronic information. We have the Children's Online Privacy Act that restricts kids from getting accounts that are under 13 years old. Some countries that's 16 years old. So we have a patchwork of different laws. But the thing to remember with that is there's no one body that is responsible for administering all those privacy laws. There are different organizations. The co-regulatory approach, as in Australia, is a partnership between business and the legal system. So they'll have standards of the different kinds of laws. But now they made an amendment to it saying that there has to be that they're only required to notify when there is a data breach likely to result in serious harm to any individual the information relates. So there has to be some proof of harm before something is considered a data breach there. 22% of small, medium businesses were impacted by ransomware. We heard in the talks this morning. That shows it is really a really big issue. And not just for large organizations, but the small ones as well. We also have the EU Data Directive of 1995 and 98. And we look to Europe in really a lot of leadership around putting together privacy laws. The 2016 General Data Protection Regulation, which you may have heard a lot about, GDPR, if you haven't, you probably don't have any consultants in your organization. Because I think there's a lot of people that will sell you GDPR work, but it really comes down to, do you know where your data is? How are you protecting it? How long are you keeping it for? Who has access to it? So we have the GDPR. What's interesting is I spend a lot of time in Europe, and what's interesting is I was in a discussion with, it was a GDPR class that we had about a year ago, and there's just as much wondering how to comply with this stuff over there as we are here. And I think sometimes we get the impression that Europe has it all together because they have the data directive and now they've got the GDPR. They're scrambling compliance too. And by the way, few organizations are really going to be compliant with this by the deadline in May. So that'll be very interesting. But that's a comprehensive approach. So you have data protection officers. Each country has a data protection authority that is responsible for administering that within their country. So here's some of the changes. This increases the territorial scope. So we're talking about EU citizens in the protecting the information for those citizens. Penalties up to 4% revenue or 20 million euro, whichever is greater. So if you have a multi-billion-dollar company, we're talking about some large fines. I think it's going to be really interesting to see what happens when these fines actually try to get levied, how successful that will be, but that's a stay tuned over the next couple of years. There's going to be some poster children made out. Some companies are going to be made examples of by not following GDPR. Consent must be intelligible and accessible. So all these little terms and conditions that we get on something and it's buried in there that we're giving consent, that's what they're trying to take care of. Breach notification within 72 hours. 72 hours of suspecting an incident, that's supposed to be notified. But there's not a lot of specifics around that yet, so I think that will be another interesting area. Right of access. People have a right to their information. They have a right to get a free copy of it. The right to be forgotten, as I talked about earlier. And of course, there's some stipulations with this too, because you have laws in the land, so you can't just have a criminal that says, well, I really want you to forget about all my past stuff there. So there's a balance there that has to be struck. So there are some exceptions for law enforcement. Data portability, it's your information. So when it needs to move to another system, it needs to be able to be portable. And then privacy by design, and there's some principles for that which I'll lay out here. And then data protection officers. If people are doing a lot of business in Europe, they're going to need a data protection officer to make sure that there's a contact when something does go wrong with this. So the OECD that I referred to earlier in that 1980 law, this is where a lot of our privacy laws are developed from, are these 8 principles. So if you understand these 8 principles, you understand, you could pretty much read most privacy laws and understand what they're protecting. So let's go through those. So the OECD, the collection privacy principle number 1, there should be limits to the collection of personal data, and any such data should be obtained by lawful and fair means, and where appropriate, with the knowledge or consent of the data subject. So that's why you see a lot of, when you're around a place, you don't mind if I film you here, do you? I think you gave your consent in all the stuff you filled out with RSA that I can video this. Is that okay? everybody? Anybody object? Okay, it's a toy anyway, so it's not doing anything. But that's why you see this stuff up there, that there has to be some limits around that. Quality principle. Personal data should be relevant to the purposes for which they are to be used, and to the extent necessary for those purposes should be accurate, complete, and kept up to date. So people can't have information that's invalid. Think about if you were going to go and get buy a new car, and the credit agency had incorrect data about you. You have a right that when people are collecting information about you, that information is correct. Purpose specification principle. The purposes for which personal data are collected should be specified not later than at the time of data collection, and the subsequent use limited to the fulfillment of those purposes or such others as are not incompatible with those purposes and are specified on each occasion of change of purpose. Basically what this says, it's kind of convoluted, but it basically says that you need to tell people at the time you're collecting the data what it's going to be used for. And if you decide to use that data for something later, it needs to be consistent with why you collected it. And we've seen, with Facebook, the exposure of a lot of information. Well, people thought they were signing up for a social platform and they were communicating with their friends. And that's what that information was used for. And so we can see why there's a lot of trouble with the third party that was using that information for something other than what it was really intended for. Use limitation. Personal data should not be disclosed, made available, or otherwise used for purposes other than those specified in accordance with paragraph 9, except with the consent of the data subject or authority of law. So sometimes things have to be disclosed to law enforcement through the proper procedures. Sometimes they can be disclosed because you gave consent for that information to be disclosed. Personal data should be protected by reasonable security safeguards against such risk as loss or unauthorized access, destruction, use, modification, or disclosure of data. This is the clause that if you're ever in a situation where your company says, we don't have a regulation, we don't follow under PCI, we're not doing credit cards, we're not doing health care, we're not used to any of that. This is the clause because they have a website, and on that website they posted a privacy policy. And on that privacy policy they have had this clause in there that said we will protect your information. The famous case years and years ago was Eli Lilly. It was one of the first people that was charged by the FTC. They had an application where people that were on Prozac could get some extra advice by signing up through this website. Well, they were shutting down this service, and the programmer accidentally, or wasn't thinking, sent out an email to all 669 people that were on Prozac in the subject line, or in the to line, and told 668 other people that they were on Prozac. And so the FTC came in and gave them a 20-year sentence of audits every 2 years and gave them a big fine. And that was really the start of a lot of this. So when you make a promise, in the way the FTC goes after people in the US, that's the regulatory arm that has been using this, it's under the Fair and Deceptive Trade Practices. So in other words, you're making a promise to the consumers that you're going to protect their information, and when you don't and you have a breach, now you violated it and now your company's at risk. But this is the clause. If you ever need a clause for your company to say why you need to do this stuff, this is it. The openness principle. There should be a general policy of openness about developments, practices, and policies with respect to personal data. Means should be readily available of establishing the existence and nature of personal data and the main purposes of their use, as well as the identity and usual residence of the data controller. In other words, we need to have transparency around it. Individual participation example, and this is where we get into you have the right to get your information, you have a right to obtain it in a reasonable cost and manner. You have a right to challenge any denials if you've been denied credit. It needs to be produced in a reasonable time. And if it's denied, they need to give a reason for that denial. And then you also have the right to erase, rectify, complete, or amend information. That's the seventh principle. And then the one is the accountability principle. A data controller should be accountable for complying with measures which give effect to the principles stated above. So the data controller is you, is the company that has the information that you're asking somebody else to do something with it. You may ask a cloud provider to store your data, but you're really responsible. Now GDPR changes that some, because under GDPR they're also making the person liable for it, that is processing that information as well. So we have a communication problem, and you may have seen this in some of your board meetings in terms of this language of privacy. So we have some definitions. We have personal data relating to a personal or identified natural person, sensitive information, or sometimes that's called special categories of personal data, and think of like your healthcare type information. And then de-identified data, the laws usually don't apply. So if you have anonymized data or encrypted data, it won't apply. Here are some of those personal information elements. And the thing is, notice one thing up here that we may not think of as personal information. What item would you say you wouldn't really consider personal information? What's that? IP address, right? But IP address, if it can identify you, is personal information. So we have to be very aware of that when we're looking at these things and not make those assumptions. Sensitive personal information is different between the United States and Europe, which adds to that complexity. Europe looks at things like racial or ethnic origin, political opinion, religious or philosophical beliefs, trade union membership, health or sex life, offenses or criminal convictions. In the US, we tend to look at social security number, financial information, driver's license number, and medical records. So the thing to remember too is that in Europe, this is really a fundamental human right. That's what came out of the data directive. It's not just about protecting information. This is a fundamental human right that people have. Here's the different roles. So I talked a little bit about a data controller. That's the company that is responsible for this information. You have the data processor who's actually processing it based on the instruction set given by the data controller. And then the person in the middle that we don't want to lose from all this is all really about the data subject, the person that we're protecting their information for. And then all of this is managed by data protection authorities. GDPR changes things, that this is a regulation. What happened in Europe is the 28 member states under the data directive each had their own laws. So it was a principle. The data directive of 1995 was a principle, and they had to come up with their own laws. Well, that didn't quite work so well because each country came up with a little different laws. So now this is a regulation, an overarching regulation, and then I won't add the complexities of Brexit in there as well. Privacy policy is an internal statement directing the employees on what to do to protect the privacy. A privacy notice is that statement that we put on our websites to tell everybody else how we're going to protect their information, what we're collecting, and how we're going to use it. Now Google calls this a privacy policy. This is actually a privacy notice. It's very interesting to me. But I looked at Google. So this is what you are giving Google This is what everybody read the consent, the privacy policy, right, that Google issued. Did everybody read all that? The multi-page document. But here's what's in here. They have a right to know which ads you find more useful, the people who matter most to you online. Oh, didn't we just have something about that, about somebody looking at person's friends' data on another platform? Videos that you like, the language that you speak. We may associate your phone number with your device. Interesting, huh? And we automatically collect and store certain information in our server logs. That's pretty clear in what they're collecting, isn't it? Just say everything. When you Google something, they have the right to everything. Opt-in and opt-out. Opt-out is processed unless the data subject objects. That's that box that's pre-checked to accept, or a checkbox to opt out. Opt-in is information is processed only if the data subject agrees, and you need to have this affirmation. And GDPR is really focusing around making sure that there is that positive consent. So let's just look at these and see which ones they are. Which ones are opt-in, opt-out? So let's look at A. Do you want to receive additional information? Yes or no? Is that opt-in or opt-out? It's opt-out, right? So it's already pre-checked, okay? Already pre-checked. So you have to uncheck it if you don't want that. So some of these are very tricky. Checkbox, let's look at B. Checkbox if you do not want to receive more information. Opt-in or opt-out? It's opt-out, right? Checkbox if you do not want to receive more information. C, do you want to receive additional information? Yes or no? Opt-in, right? I have to check it. This is where I'm giving that affirmative consent that you're going to see more of. D, please send me more information about your products. Checked. Opt-in or opt-out? Opt-out. I have to uncheck that box or I'm going to get stuff. So after this conference, right, you're going to get a whole ton of emails from people on the floor. You might see some of these things. Program design, this is just in your slides to show that there is a life cycle around privacy. Privacy by design, there are 7 principles. Basically, that privacy should be proactive and preventative and built into the design of things. It should be privacy by default, not added on later. It should be embedded in the design. It's a positive sum, not a zero-sum game. The end-to-end life cycle protection, so you're looking at the data all across until you get rid of that information. Visibility and transparency as far as what your practices are, and there should be respect for users. So I just want to show you real quickly here. Anybody have one of these? A Hello Barbie? Well, I know this sounds really creepy, but I bought this, okay? This is an Internet of Things toy. And I bought it at Toys R Us when they were still in business. And I took it home, and I wanted to see how this thing worked. And so I hooked it up to Wi-Fi, and what Barbie does is it has like 5,000 to 7,000 things that it can say back to your child. And so you download this app and you set up Barbie, and you can talk to Barbie. Your child talks to Barbie, and then Barbie talks back. And it records the conversation. But there's an app, so the parent can see what's recorded in the conversation. So I looked in the app. It requires an email address as a logon. Great. So I put my email address out there, which, by the way, you can find my email address very easily online. Just Google my name. You'll probably find it pretty quickly. But then needed a password. I thought, great. So what would be a good password? Barbie? Okay. Well, you know, it's not really strong enough. We're security people here, right? So let's make it a little longer. How would we make that better? Barbie 1. Well, that's a little bit short. So what should we do? Barbie what? Barbie 1, 2, 3, 4. Well, okay. So Barbie 1, 2, 3. How long did that take us, right? That's my password that it accepted. So you can go online and you can listen to my conversation with Barbie. Now, I find this very creepy. This is in your child's room talking to your kid. So that's creepy enough. So that's privacy not built in. So then along came this guy, right? He's a little dinosaur. He does different colors and he talks and he'll tell you stories and he'll play games with you. And it's actually a pretty cool little toy. It has IBM Watson on the back end of it. So I read the privacy policy. They do encryption, they cycle the keys, they're doing all this stuff. I'm still not clear what data they have and where they're putting it. That piece was a little bit left out. In the privacy policy, it said that we encrypt or anonymize your data all the way through the process. Not quite sure about that. But this is the future. These are the toys that are going to be in our kids' rooms collecting information and learning things about our kids. So today we looked at privacy, why that should be important to the privacy officer, the 8 different principles, global laws impacting the privacy, how we build that program through the privacy design principles, which was first put out by the Commissioner of Canada, came up with that, and then understanding the data elements in the language of privacy. Like I said, I'll be doing a book signing right after this. Here's just a suggestion. Do something when you get back. I would strongly recommend you meet with your privacy officer or legal department, build that relationship. Read some of these laws and start to get familiar with them. And I would also, the IEPP, are you familiar with the IEPP? I'm not trying to do a promotion here, but they have some great stuff, and I don't know of anywhere else that has it yet. It's the International Association of Privacy Professionals. They have certifications in US law, EU law, Canadian law, wherever you are, but it will drive you to learn a lot of detail about this stuff beyond the certifications. So I just leave you with this closing slide, and hopefully your privacy program doesn't look like this.